Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. If you have not had the opportunity to review two prior presentations that we published recently and the documents that were unsealed within this past week that those presentations relate to, I request that you do. It will provide you with feedback going into this presentation, which is on state's response regarding defendant's motion for independent analysis of evidence. And just by way of background, our first presentation dealt with the June 2nd, 2025 response to Mr. Kohberger's discovery request that centered on two pieces of evidence that were seized at the time of Mr. Kohberger's arrest back on December 30th, 2022 in Pennsylvania. Specifically, his Samsung phone and his Acer laptop. The second is a motion that came 4 days after those responses. It is motion regarding independent analysis of evidence filed by the defense on June 6th, 2025, and then we see a very quick response here. We know that by looking at the upper right-hand corner. This filing, the response to the motion, was filed at 4:07 p.m. June 6th, 2025, same day of defense's motion. What does this say? The title states response regarding defendant's motion for independent analysis of evidence. It reads as follows. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully informs the court the state does not object to the defendant's motion for independent analysis of evidence so long as this analysis is not used as a basis for a motion to continue the trial. The state notes that defendant received the extractions and, in parentheses, digital copies of these items on April 4th, 2023. The physical items of evidence, in parentheses, the Acer laptop and Samsung phone, have been available for analysis since July 22nd, 2024. Respectfully submitted this 6th day of June 2025, Ashley S. Jennings, Senior Deputy Prosecuting Attorney for the Latah County Prosecutor's Office on behalf of the state of Idaho. There's 3 points that I would like to make at this time, purely commentary, opinion, speculation on my part. First, the state here is telling the court and counsel, opposing counsel, we have no objections. Conduct this independent analysis of evidence, in other words. State says here, just as long as whatever this analysis yields, good, bad, or indifferent, by your expert, defense, can't be used as a basis to continue this trial. Secondly, the state is making a point here of advising the court that the defense received the extractions, the digital copies of these two items, the phone and the computer, on April 4th, 2023. So the rhetorical question that I asked is, doesn't appear here or in the motion that the defense raised some sort of a red flag at any time between April 4th, 2023, when they received information regarding these extractions, according to the state, and the date of the filing of the motion, which was over 2 years and 2 months later. And then in a related rhetorical question. The actual physical items of evidence according to the state, this laptop and phone, has been available for the defendant to physically conduct an independent analysis of the phone, of the computer, for the better part of a year before this motion was filed, as it was on June 6, 2025, ever since, per the state, July 22nd, 2024. So the question here is, what changed between July 22nd, 2024, the time that the defense had to ask for these two items to be turned over to their designated expert to conduct their own independent evaluation and see if whatever that evaluation yielded, whether it was exculpatory, favorable to Mr. Kohberger, or inculpatory, not favorable to Mr. Kohberger. What changed between April 4th, 2023 for the defense to at least not raise a red flag, put the state on notice that it would want to do an independent evaluation? It appears that something in my mind, speculating here, happened to cause the defense on June 6th to file this motion for the first time. And unfortunately, we don't have the answer because the motions didn't provide it. And this response is just basically saying we don't have any objection to raise at this time, just so that whatever this report from the defense expert yields can't be used to continue the trial that had been set since October of 2024 to commence in August of 2025. The court did render an order just a few days later on the 9th of June, and it is entitled Order Granting Defense Expert Analysis of Evidence. It reads, the court having before it motion for independent analysis of evidence and good cause, appearing now therefore, 1, it is hereby ordered that the aforementioned evidence shall be made available to defense expert name redacted by the Moscow Police Department and or other agency in possession of the same for independent testing and review by an independent testing agency. 2, it is further ordered that redacted shall, at the defense counsel's expense, be allowed to conduct the independent testing of this evidence, and specifically the Acer laptop and Samsung phone belonging to Brian Kohberger. 3rd, it is further ordered that the chain of custody shall be maintained on the evidence at all times. Moscow Police Department shall hand deliver and or ship the evidence via FedEx directly to name redacted, who will ship the evidence via FedEx back to the Moscow Police Department upon completion of testing. The evidence should be shipped to attention, and then there is information, as you can see here, that's redacted. Now going on to page number 2. It is further ordered that upon completion of testing by an information redacted is to immediately notify and see Taylor to arrange for transfer of the evidence back to the Moscow Police Department. And then finally, it is further ordered that the results of the testing shall be considered work product of Mr. Kohberger and or his attorney, and said results shall be submitted solely to the office of Ann C. Taylor. So ordered June 9th, 2025. And you see Judge Stephen J. Hippler's signature there as district judge and jurist presiding over the Idaho versus Kohberger case. If I could make some points here, ladies and gentlemen, opinions, commentary. First, we see here that the court changed the title of the motion and the response. The motion and the response stated independent analysis of evidence. The court said, nope, we're going to scratch out independent and we're going to write in 2 words, defense experts. So, order granting, defense experts, analysis of evidence. That's the title of this order. So we see here that Mr. Kohberger got the relief that he was asking for. Remember, a motion is an application or a request for a court order granting something, and it's granted him this relief for this independent evaluation. However, there's some conditions put on here. Number 1, it's going to be made available to the person whose name is redacted here by the Moscow Police Department. And if the Moscow Police Department on the day of this transfer doesn't physically have these 2 items for some reason, then the other agency that might have this Samsung phone or computer in their possession is to make arrangements to be transferred for this purpose, independent testing and review by defense expert. Next paragraph, it looks here that Judge Hippler is making it clear that whatever this costs, the cost of shipping, anything else, and also for this defense expert's time, it's going to be paid by defense counsel. Now, is there a possibility that defense counsel then tried to apply for reimbursement of these costs? Yes, there is, but at least as of the time of this order, the court made it clear who would be paying for these services and any costs and expenses associated with it. Then the court is emphasizing something that we had addressed in our prior 2 presentations that were also addressed in the documents, those presentations related to this issue of chain of custody. Court's making it crystal clear here, chain of custody shall be maintained on this evidence at all times. And then he gives further instructions on how the evidence is to be transported from the possession, custody, control of the Moscow Police Department directly to the defense expert. And then when the expert's done, going to turn around and do the same thing. I asked the rhetorical question. I've questioned why the name or even the job title of the person that this evidence was to be shipped back to at the Moscow Police Department is redacted here, but it is, as well as any address that might be under seal. And then finally, the court has made it clear here also that the results of defense experts' finding, usually that's done in a written report, is going to go only to Mr. Kohberger through his attorney. It's not something that is to be shared with the state, with the court. This is to be considered either work product of Mr. Kohberger and or of his counsel. So as we analyze these 2 documents and the 2 documents that we had previously addressed, again, I ask rhetorically is why then? What happened in the days, the weeks, maybe the months prior to June 6, 2025 to cause the defense literally almost on the doorstep of the courthouse steps, preparing for voir dire, which is jury selection and trial that would be happening very soon after this motion, response, and court order was filed. Secondly, what were the results of that expert's finding? It's considered work product at this point. It's considered Mr. Kohberger and or his attorney's work product. So it would be very curious to see what that defense expert opined, what that defense expert found. If you have any comments, thoughts, opinions relative to this matter, please leave them here. And until next time, this is Kathy. Thank you for joining us today.